Hi everyone, so for this post I'm going to be talking about how Apple lost more than $500 million to a non-practicing entity. I got this from an article on Fortune magazine and the link is in the description, so go ahead and check that out. So basically Smartflash is the non-practicing entity, and it's a small technology developing and licensing company in Tyler, Texas, started by a man who grew up on a farm with only an 8th grade education. So Patrick Raz, the founder of Smartflash, and his background were of large attention to the legal team of Apple in a recent patent infringement court case originally filed in 2013. So the case that Smartflash brought up against Apple was that they infringed on 3 of their patents involving data storage. So the patents in question were all valid, and they were filed by Patrick Raz himself. And so later he makes that a point to prove that his firm is not a troll, just a non-practicing entity. So when the court proceedings took place, Smartflash had all their proper questions ready to address and focus on the specifics of the case, whereas Apple, on the other hand, called several witnesses to speak in their favor and to prove that they did not willingly infringe on any prior arts. However, when they called Rash to the stand, they simply intended to show that he lacked an educational background and that he was not qualified to hold such patents, and then targeted him as a troll as fishing for licensing fees. So they attacked him with ridiculous questions, and according to Brad Caldwell, who was Smartflash's legal counsel, quote, "They acted like we're Apple and we have no need to respect other people's intellectual property," end quote. But as we all know, all IP needs to be respected or else face the consequences. And in this case, Apple's consequences amounted to over $500 million in damages payable to Rash and his company. So the reason I chose this case is that this case showed NPEs in a somewhat positive light, in the fact that they were a small company fighting for their patent rights against a large company that simply aimed to dominate the industry by means of their reputation and their deep pockets. So in my next post, I'm going to do the same type of analysis, just with a different case, and in this instance I'll show how a troll is pretty detrimental to the patent industry. So until next time, thanks.